Kathy Baker is on the list to speak, and Tammy Zagrandi, is that right? And Masood wants to say a few things. So if we have time to fit more people in, we'll fit more people in. Okay, for our research here. Okay? So, Wendy, nice to meet you.
Nice to meet you as well. I've heard that you're very welcoming, so I welcome that opportunity because I'm not used to speaking in this.
Well, that's part of what I try to do, is to make people feel as though they feel respected. And you are. So. And these candy canes.
Yes, I'll have one if I start getting, I'm sure I'll start getting a dry throat. Good afternoon. My name is Wendy Knelsen. I'm an injured worker, and I'm also the facilitator for the London and District Injured Workers Group. Our local group has been in existence since 1989 with various names. Our most recognized name was the Repetitive Strain Injury Group in London. However, we are now called the London and District Injured Workers Group. I joined this group as an injured worker and later became a co-facilitator until the founder and executive director left the organization.
What does that mean to be a co-facilitator? What do you do?
Setting up meetings, trying to find guest speakers, getting information and pamphlets that are helpful to workers, CPP disability, OWA information, that type of thing. And I've been the facilitator ever since he left. I'm also the national representative for ONIWG, the Ontario Network of Injured Workers Groups. I'm making this submission today with very mixed emotions. A large part of me agrees with many injured workers and advocates that are not participating, as they feel the board has continued to make changes and cuts to injured workers' benefits, no matter what injured workers groups say, advocates, labor, and disability groups have said. In 2010, the W.S.I.B. hired private consultants from KPMG to conduct an audit of its claims processes. Instead of staying within its proper scope and assessing the effectiveness and efficiency of the board's work, KPMG told the W.S.I.B. to do a widespread review of its policies and legal framework in order to cut benefits to supposedly overcompensated workers. The W.S.I.B. has said that it will accept KPMG's recommendations. W.S.I.B. management's endorsement of KPMG's recommendations shows an utter disregard for the foundational principles of the workers' comp system and undermines the rights and dignity of injured workers in this province. KPMG's recommendations are accepted by the board, and we strongly believe are already in practice at the board. We further believe that if they are fully implemented, many more injured workers and their families will suffer. Their benefits will be cut shortly after injury, and they will be refused help when they are laid off or their injuries worsen. Under a deferred prosecution agreement, KPMG admitted criminal wrongdoing in creating fraudulent tax shelters to help wealthy clients dodge $2.5 billion in taxes, and agreed to pay $456 million in penalties.
Can you just say that again, what they did?
Yes. Under a deferred prosecution agreement, so they did come to an agreement, and you would understand this better than I, obviously with your background. They admitted criminal wrongdoing in creating fraudulent tax shelters to help wealthy clients dodge $2.5 billion in taxes, and they agreed to pay $456 million in penalties. Now I ask you, Mr. Thomas, why would the board hire a company with this reputation? And if I may, I will answer that for you. Because KPMG will ensure it writes the report the board wants. A report that supports making deeper cuts to injured workers and their families. There are many advocacy groups that believe the underwriting theme for both the appeals and benefits policy consultation are a direct result of the KPMG report. This report reflected a fixation with bringing finality to a claim, and these are their words, and closure to individual cases. This report does not acknowledge Meredith's principle that there should be security of payment for injured workers as long as the disability lasts. I can assure you that our group supports this notion and also believes that it is the very reason we are here today. KPMG suggests injured workers and their representatives are trying to manipulate the system without any evidence to support this fact. However, in fact, there has been evidence to indicate that employers are indeed the ones trying to manipulate the systems, not the injured workers. The parallels between the concerns of the board and KPMG audit are seriously disturbing. the Injured Worker Group has serious reservations that the KPMG audit was a proper value for money audit at all. It appears this so-called value for money audit is merely a vehicle to advance the corporate agenda. Just going to grab some water.
Yeah, please do.
These recommendations completely betray fundamental principles of workers' compensation, and I believe, and our group believes, they violate the Act itself. After Professor Harry Arthurs conducted the funding review, many recommendations were made, admitting that the system was not meeting injured workers' needs. However, the board's only focus seemed to be on implementing full funding to address the so-called unfunded liability. We believe the use of the unfunded liability and the so-called financial crisis board has always been brought forward in attempts to make legislative changes and/or policy changes that diminish benefits for injured workers. The board is not, nor has it been, in financial crisis, and employers are still enjoying a lower premium rate than they had in 1997. I ask you, Mr. Thomas, where is the justice in that? The board has previously disregarded and/or handpicked from consultations, which really has meant injured workers continue to be subjected to an increase of ongoing cuts and denials to benefits. Even the recommendation to address the inadequacy of the distribution of cost of living allowance by esteemed Professor Arthurs was ignored when the board and the government provided a meager 0.5 increase to injured workers in 2012. That being said, I still believe it is essential to document our ongoing concerns with the way the board is dealing with injured workers and the proposed changes here in the benefits policies. As an injured worker group, we collectively agree that there is many issues with the current system that need improvement. We do not agree that the problems lie within the policies themselves, but within the culture of the board and the current mandate of cutting costs. We vehemently disagree with any and all changes to the policies where the underlying intent is to limit entitlement. Sadly, with what we have seen and what we have heard, we believe that is exactly why we are here today. First, we are concerned that there are a huge number of injured workers that are not even aware of this consultation as taking place, nor are they aware of the ramifications of changes being proposed by the board. We are also very concerned for the high volume of workers that would not be able to read and interpret this paper and the case scenarios. There are many temporary, foreign, migrant, and illiterate workers that simply wouldn't be able to understand all of the implications of these documents. We also feel it is integral to ensure this process is accessible to as many workers as possible, even though they may find it challenging to review these documents. Even many of us that have English as a first language are finding it demanding to decipher this extensive discussion paper and supplementary case scenarios.
No, I tried to write it in plain language.
I know,
really did.
I know.
I don't disagree with you, Wendy, that it's I think John McKinnon from Injured Workers Consultants on the very first day talked about, he used the word accessible. How do you make this, how do you make these very complicated and difficult topics and concepts and words, how do you make it accessible? And there's a way to do it. And all I can say to you is that what I can say that I hope would be of some comfort is that a lot of injured worker representative groups like you and like others have spent a lot of time writing very thoughtful submissions, have come and spoken to me, the Ontario Federation of Labour, the Injured Workers Consultants, district groups in Thunder Bay and other places have come, Hamilton, ONIWG in Hamilton. So there's been lots of, so just to give you some comfort, I know it's not a full answer and I'm not taking away at all from your concern about why isn't this more accessible to more injured workers. I think I'm very aware of that as being an issue. I'm trying to find ways to keep the language plain and simple, and I know I'm probably not succeeding everywhere because that's just, in some respects, that's the nature of what we're talking about, but your point is taken.
I appreciate that. And I think within that is hidden some serious systemic issues. The accessibility to, it's not part of my presentation, but the accessibility to statistics, to access to injured workers, so that whether it be through OWA or through the board, so that they can be informed of these things. And I think that goes to show that the board truly doesn't necessarily want to hear from all of us. I think all the huge stakeholders are involved. But there's so many stories out there that, you know, I mean, I wanted to cry when I heard Michelle talk, and I could very easily, you know, fall victim to the same thing while I'm talking to you. So I think there's so many that aren't here for fear and of retribution by the board, that anytime the board's involved, there's many that are afraid to speak out. And I understand that from the history of things that have happened.
On the other hand, they appointed me.
That's right, and I appreciate that as well. So Professor Arthurs pointed out in his Funding Fairness report that many groups have very limited resources to invest in technical consultations. Our local group has no funding, no office, and no resources. I am only a limited part-time volunteer with very little training that tries to do what I can do, despite the physical and emotional effects of my injury and the injustices I've been subjected to both by my employer as well as the dysfunctional system. Also in Professor Arthur's report, he characterized the current workers' compensation debate as one between the merited principles and the insurance model of workers' compensation. We feel this is an important issue for this consultation to review and provide feedback on how this insurance model of adjudication is affecting the success of the board and its policies, and not the policies themselves. If the changes suggested in this paper, as well as the supplementary case examples under the administration of Mr. David I. Marshall, are implemented, injured workers across this province will be denied further justice through this very consultation, as well as the benefit policies themselves. Policies should truly reflect Sir William Meredith's principles. These include no fault, employer pays, injured workers receive payments for as long as their disabilities last, collective liability, public system with independent board, and most importantly, non-adversarial, which is not the system we have encountered. We feel strongly that historically whenever a change in policy occurs as proposed by the government of the day and or W.S.I.B, is change the spirit and intent of the Act as well as Meredith's principles, and always ends up to the detriment of injured workers. With drastic, devastating changes to legislation, we also saw the change in name from Workplace Compensation Board to the W.S.I.B, indicating a clear shift from a system based on Meredith principles to an insurance model. Professor Arthur stated that if the legislature wanted the board to behave like an insurance company, it would need to do more than just change the mere title, that they would need to reconfigure the entire Act. We do not believe that that is necessary. We just believe they should comply with the Act. The consultation discussion paper that the workplace states that the workplace world has changed enormously over the past several decades, as have the demographics of the Ontario population, perhaps the most significant of which for these purposes is an aging workforce. It also states the advances of medical science and in our understanding of the interactions or links between work-related and non-work-related factors may usefully contribute to better adjudication. The only fair, reasonable way to deal with the aging issue and degenerative conditions is on a case-by-case basis, using common sense and evidence available. From our dealings with the board in previous consultations, this overriding theme on aging, degenerative conditions, and recurrences just reinforces what has already become apparent and already occurring. The board is looking for more ways to justify denying further benefits and saving costs. As far as the case scenarios, aggravations, recurrences, and permanent impairments that have been recently presented to be considered for submissions, we feel that they are not a true reflection of actual case examples, and this is just another way the board continues to stigmatize injured workers. It strongly supports our belief that the board has become a culture of denial, and this and other consultations are merely a method to cut benefits to injured workers deeper so that they may have an increased cost saving. We do not feel these scenarios reveal problems with the policies, but with the adjudication and so-called best practices. We do, however, look forward to your report being an accurate reflection of the current system and its failings, as well as recommendations for real and significant improvements to the system. The current work disruption policy effectively assists injured workers in finding alternative work and provide them with support to return to employment after a work disruption. This reduces burdens on social services and government agencies and allows workers to contribute to their communities. We do feel, however, that it would be beneficial if this were more widely known amongst the working community so that people could access benefits they should in fact be entitled to.
you feel the work disruption, your submission, you're saying the work disruption policy isn't well enough known.
Known and or understood. That's correct. both from layoffs and from plant closures. There are many workers that do not understand or know that they have those rights. And I think if that was more well known, more people would be able to access that, which they should be entitled to. Having a disability and going back out into the workforce really puts them at a disadvantage. We strongly concur with ONIWG and other advocacy groups that believe that many of the concerns and suggestions of the board with the subject policies betray a lack of understanding of the Meredith principles, as well as the Act itself. We feel that many of their concerns are a threat to injured workers' security of payment for work-related disabilities. Their mandate has been replaced with a financial mandate under the direction of David Marshall to cut benefits and enjoy cost savings. It appears that the board's main focus of concern is that there is a lack of tools to allow them to deny responsibility for work-related injuries. We concur once again with ONIWG that this betrays the foundational principles of workers' compensation and violates the Act. For these reasons mentioned, we do not feel changes should be made to the policies on recurrence, permanent impairment, and aggravation basis. Now, in your discussion paper, you asked 3 questions. And I just have a few comments on each of those questions that hopefully will help you.
Will you be able to leave this with me?
I can send that electronically if that's okay. I have a couple errors that I was tweaking.
Not a problem. Just
okay.
I mean, this is a very, very helpful submission. When that's why I'm saying that. So
yes.
I'd like to make sure we have a copy.
Okay.
I have a copy.
Absolutely, yes. We do not believe there is fault within the policies themselves, but the system and the adjudication of policies and internal guidelines. If the policies must be revised, it is critical that the process includes a third-party review that include meaningful outcome measures, including tangible and intangible factors. For example, including evaluation of quality of life measures, pain, mental/stress level, ability to perform activities of daily lab living, and also including long-term follow-up of return-to-work outcomes. Accessibility is imperative. The policies must be reviewed to include parallel documents that are rewritten in multiple languages and in an easy-to-read and easy-to-understand format. Modern medical advances are amazing, but the board repeatedly deems specialist reports, clinicians' reports, inadmissible or not allowed or not approved prior to submission. This thereby resulting in an extremely narrow and biased subjective view of information to be used in the injured worker's case. Clear direction must also include enhanced accessibility, readability of all documents, comprehension for lower education levels. We do not feel that revising these policies should be done at a cost savings measure, which the board has already been practicing, contrary to the Act and the spirit of the Act. Question 2. You don't need me to obviously read them out loud for everyone. Although the issues set out in chapters 3 to 6 are important and relevant, I feel there needs to be much more emphasis placed on figuring out, recreating, rebuilding a new culture within the board, one that supports the true spirit of the Act to support injured workers. Unfortunately, there is a lot of mistrust, fear, and anxiety and despair by injured workers based on unreliable, unprofessional, inconsistent, unhelpful, undignified, and disrespectful dealings with the board. The system has to be revised so that injured workers know they have an institution in place that is genuinely working for their benefit and not the bottom line. The consultation process would do well to attempt to address and resolve the permeating culture of mistrust and lack of respect between the board and injured workers. Ideally, all parties, including the board, employers, and injured workers, should be collaborating and expending resources wisely to accomplish common goals. Not just in writing, but genuine collaboration in a spirit of goodwill and fiscal responsibility. Question 3. What we hope to expect from this process: empower the injured worker rather than make them feel like a criminal or a liar. Encourage the injured worker to seek out a variety of trust modalities to help and recover rather than being forced to see W.S.I.B. contracted clinics, therapists. Subjective examinations are a problem and fuel mistrust. Eliminate the conflict of interest. Board contracted clinicians are perceived as highly biased and working for the benefit of the board. their bottom line and not healing the injured worker. Eliminate the significant differences in professionalism, integrity, compassion, and decision-making skills of case managers and their respective managers. Eliminate the culture of the board working for employers first and injured workers last, if at all. Adjudicators, now called case managers, have told injured workers they are not government funded, but rather funded by employers, and that's whom they have to answer to. Bring back the spirit of the Act so it once again is a system to help support injured workers, not an institution that merely protects employers from being sued. Re-establish trust in the W.S.I.B. that they are working for the workers, not protecting the employers from litigation only. As you can see, I put a lot of thought into this.
That's great. It's really good.
Re-establish a fair, timely, and dignified process of appeals so that injured workers have a reasonable way of having their issues heard. WSIB holds people's lives in their hands and keeps them on edge with threats of non-compliance, of withholding benefits or lost wages, or canceling benefits altogether. It is time to eliminate these intimidation tactics. Eliminate the attitude of guilty until proven otherwise. The board suggests an injured worker is lying and deceiving until he or she proves otherwise. In addition to that, they use a biased medical practitioner to rule as the board sees fit. In the interim, injured workers and their families are forced into poverty. Eliminate the ability of the board to be able to wrongly refuse or disallow specialists and medical reports submitted on behalf of the injured worker's case. Eliminate the disconnect between what is written in policies and procedures and how injured workers are truly being treated out there. Recreate an institution with third-party review, checks and balances that prevent the board from having ultimate power and using intimidation, degrading tactics, and coercion to control, provoke, and/or influence injured workers. Re-establish that what is written in this consultation report is actually implemented for the benefit of the injured worker and not for the bottom line. Change the perception that the board has the means and ability and power to do what's best for the employer, the bottom line first, before looking after the injured worker in a fair and respectful manner. We also have a few additional issues, including appeals modernization, deeming, Schedule 2, WSIB decisions, experience rating, RSI, MSD injuries, ergonomic legislation, and universal coverage. Providing the quickest training possible and then deeming injured workers into phantom jobs they don't actually have is simply wrong and not in line with Meredith's principles of full justice and the spirit of the Act. Deeming injured workers is truly demeaning, and it is deeming them and their families into poverty. Our group sees little value and great potential destruction in the proposed changes to the appeals system.
Just on the deeming, where does deeming show up most?
Deeming mostly shows up when you have a worker who has been off for a very long time and has not been re-employed back with their accident employer. And then all of a sudden the board has decided, for instance, that Kevin here would all of a sudden be able to do set job, whether it be customer service or whatever. And so they deem him able to make a certain amount of money, and he gets 85% of the difference of pre-accident earnings and the earnings that they deem him able to work.
So it's more on the back to work part of it.
Even though he doesn't have a job.
But that's the part of
the return to work,
the process that you're saying you see it most.
Well, that's where it's mostly seen, but we're seeing it more and more right now in long-term, highly disabled employees who are all of a sudden deemed able to go back to work right before the 72-month review. And that is intentional, and it has resulted in over, I believe it was $630 million in 1 quarter alone in cost savings to the board. That's huge. Schedule 2 employer groups. This rating system should be removed completely. The dollar-for-dollar pay system lends itself to create an adversarial relationship between employers and injured workers, and ultimately the board. Harassment, discrimination, and intimidation are all subjected on the injured worker in the name of experience rating, and it is shameful and it should be eliminated. The employers will place doubt on the legitimacy of the claim, whether it is work-related blame it on extracurricular activities of the worker or on previous employment of the worker. WSIB decisions and prevailing jurisprudence. It is frustrating for both injured workers and employers when the board makes a decision that is inconsistent with prevailing jurisprudence and legislation. The position of the board decision makers is that they are not bound by WSIB decisions, even though when the WSIB reversal of the issue comes through, they are bound by that. It's absolutely ludicrous and it should be removed. They should be bound by precedent cases and decisions. Experience rating. For the aforementioned reasons, we believe the experience rating should be eliminated. It would provide a huge amount of financial savings to the board and create a more collaborative system for all parties involved. I have had the unfortunate experience of having been injured while working for a Schedule II employer, as well as the effects of experience rating. And this has changed my life dramatically in so many ways, many of which I'll never recover. I have experienced an employer who said they supported me 100%, but then Human Resources checked off the doubt it's work-related box on the form to the board. I was denied access to my W.S.I.B file when I suspected this had happened, and I had to do a FOI request just to confirm what I had already suspected. I've had my employer harass and intimidate me, treat me differently, and mock my injuries and my disability. I've had my employer suddenly start to question my competence when I had previously always received perfect performance appraisals. I had the board not assist me with any mediation and felt forced to leave my job in tears because I couldn't handle the physical and emotional abuse I was subjected to any longer.
What sector were you in, just out of interest?
Municipal.
London?
St. Thomas. I encountered a system with built-in biases that accepted the employer at their word, yet questioned everything I said or I submitted. This despite the fact that the employer told one story to W.S.I.B and a completely different one to Human Rights, when I felt I had no alternative but to seek assistance through that system. I have had isolation, depression, family issues, and many injured workers suffer physically, emotionally, and financially. Not just them, but their family and their children. And many injured workers become in poverty. I was one of the fortunate ones that I had a spouse and I had a support system in place, but many do not, and that is not right. I can only pray, Mr. Thomas, that you will do the right thing here and ensure injured workers and their families finally get justice and return the system to Meredith principles. Experience rating and Schedule II rate groups has to end. RSD, MSD injuries. Almost half of all lost time claims are repetitive strain injuries, otherwise known as musculoskeletal injuries. These injuries, if not provided adequate healing time, become chronic and painful and cost everyone, including the board, employer, and the injured worker. The human costs are incalculable, affecting the injured worker, their family, and their community. For many years, we have been stating that the injured workers that fall under this category are continually denied compensation due to supposed lack of objective medical evidence. This has provided the board ample opportunity to save costs by denying injured workers their lost wages, benefits in the form of braces and/or medical care. There has been and continues to be a critical need for ergonomic legislation. And I can say from a personal experience that these injuries affect every facet of your life, both personally, professionally, recreationally, emotionally, and physically. And with it being half of all lost time claims, why are we not doing more? Other than denying these claims and having injured workers have to repeatedly, I had a doctor, a chiropractor, a physiotherapist, occupational therapist, specialist at a RSI clinic, and all of them said the same thing, and yet the board continued to refuse my claim. Years and years later, I've finally gotten parts of it approved, but still I'm fighting. That is just not right.